Imagine this. Your loved ones are left sorting through a maze of legal hoops, spending months or even years in court, simply to access the assets you worked a lifetime to build. Does that sound like a nightmare? It does to me. Well, it's a reality that can happen to you if you don't understand the critical differences between a will and a trust. In today's episode, we're revealing the secrets behind these powerful estate planning tools. Secrets that could save you, your family, and friends time, money, and stress. But here's the kicker. Not every situation calls for a simple will or a standard trust. Which one do you really need? Stay with us for today's episode of Legacy Talk to find out.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. On today's show, we're talking about unlocking the secrets of wills and trusts and what you need to know. I'd like to start today's episode with a story. And this story is about a client of mine named Jennifer. Jennifer came to me about a year and a half ago with a problem, as most clients come to me with. Her sister Amanda just died. Amanda was a single woman. She didn't have any children of her own, and she had a will. Typically, when someone comes to me with a will in their hand, wanting to do a probate, things don't go too bad, right? Amanda's will was simple. Because she didn't have any kids, she gave everything to her sister and her brother, Jennifer being her sister and her brother Steve. Jennifer didn't think there'd be any issue with this estate. Asset-wise, the estate was simple. There was a house, there was some money in the bank, of course, there were some vehicles, one of which was a classic 1950s car, and a house. One wrinkle was that this house was owned by all three siblings, and that led to the first problem. The second wrinkle, or first problem in this case, was that Steve had died before Amanda. And so in order for that house to be sold, which is what everybody wanted to do, everybody meaning Jennifer, the house had to be sold. But in order for it to be sold, Steve's name would have to come off the property. And I'll back up a minute. Probate is basically a proceeding with the court to have an executor appointed or someone put in charge of someone's estate. And Jennifer in Amanda's will was named as the executor, the one in charge. Now Steve didn't have a will, and Steve's estate was being managed by somebody else, someone that we didn't even know. In addition to this, Steve had one child, a son, who had one time tried to become executor of his dad's estate, but wasn't able to do so. We're not sure why. And then once Amanda died, tried to become executor of his dad's estate again, and was successful somehow. So really don't know the answer to that question. We weren't too worried about that initially. Jennifer had sold the property, or had an offer and a contract to sell the property, which was close to closing, when Steve's son came in, having been appointed the executor of his dad's estate, and put everything on hold because he didn't trust the realtor that was involved. He didn't trust that Jennifer was doing things in the best interest of the beneficiaries, and put everything to a stop. The buyer walked away, the earnest money was lost, and the house sat. Now, if everybody would have agreed on this, it would have pretty much been a very simple probate, and it would have been over within a matter of months. But because there was the problem of having two probates, everything was basically turned upside down. And so the house sat, and it sat, and it sat, because no one could agree on who would sell the house, how much the price would be, and when it would be sold. In the meantime, Steve's son started moving people into the house and took basically full control of this house because Jennifer, being an older woman, wasn't able to do much with regard to the house and wasn't able to go up there. It was about an hour from her house. And so the house sat and it sat and it sat until Jennifer was fed up and filed a case to basically force the sale of the house from the other estate in order for this estate to close. And so even with a will, which you would think would be straightforward as far as dictating where everything went and appointing someone in charge, even with a will in this case, this probate was a nightmare. The estate was open for well over a year, when at that point there was no end in sight. It wasn't until at least a year later until the thing closed. And so today we're talking about a will versus a trust. Now, the differences between a will and a trust are many. There's also many similarities. The reason I shared that story, though, is because even though you have a will, it doesn't mean that you're going to have a simple process to administer your estate. So the first thing let's talk about here today is probate. And I think the answer to this question was just answered. Why is it important to avoid probate? Why is it such a big deal to avoid probate? And how do wills and revocable trusts differ in handling that scenario, right? Well, I think from that story you found out why you want to avoid probate, right? You want to avoid probate because anything can happen, right? Anything can happen. And oftentimes the worst happens. Probate in itself is not the worst thing in the world. It's an orderly process to basically administer someone's estate that died. It's like a title clearing process. So when someone dies, someone has to sign their name on their behalf. That's what probate is. It's a process of getting somebody put in charge of your estate to sign your name, to sell a house, deal with a bank account, things like that. So what's the difference between a will and a trust with a probate? With a will, you're always going through probate because the will doesn't give the executor or the one you put in charge any authority. The authority to administer the will or manage the will comes from the court. And the court has to give that authority to the executor or personal representative, or if we wanted to simplify it, the person in charge. Okay. Now, James, what's the difference between a will and a revocable trust with probate? A revocable living trust does the same thing essentially as a will, right? It distributes assets that someone has, as someone is designated. Okay. The difference between a revocable trust and a will is that revocable trusts, as long as they're funded properly, avoid probate. They don't have to go through that court process. They don't have to go to court. And the reason why is the trust has authority granting provisions, which we'll get into later in later episodes, I guess. But it doesn't have to go to court because the judge doesn't have to sign to appoint somebody. Okay. And because it doesn't have to go to court, it makes it much more difficult for people to contest it. It makes it much more time consuming and costly and arduous, I guess you could say, for someone to contest it and make fusses about it because it requires a whole other lawsuit. Whereas with a will, you've already got your lawsuit open. That probate's open. And because we're avoiding probate, with a trust, you're keeping things private. Whereas with a will, going through probate, everything is public. So many people don't realize that wills become public record when someone dies. And the reason that the trust keeps everything private is because you're not going to court. So why does that matter? It's because you don't want your neighbors knowing every little thing that you have, right? You don't want your relatives that you may not be getting along with, that you may have disinherited, right? You may have said, you're not getting anything in my will because you've treated me badly, or I don't like the way you're living, or we had a falling out, or whatever. They don't get to see it either because it's in a trust. Especially since they're not a beneficiary of the trust. They would not be getting anything from this trust or will. Now, what is the difference between a will and a trust as far as timing during your lifetime? So wills are documents that you sign during your lifetime, but they don't kick in until after you're passing. But trusts work differently. And the timing impacts things, right? The benefit of the trust over a will in this scenario is that the trust can be managed during your incapacity. So if you can't make a decision, then the person that you name as trustee of your trust, that's the person in charge of the trust, takes over. They can manage your affairs, your financial affairs under the trust, your affairs under the trust, okay? Whereas with a will, that doesn't happen. That's not a thing that can be done, which leads to things like guardianships or conservatorships, which are like probate for someone that's alive, which is even worse than a probate, I'd say. So the timing on the will and the trust is different because the trust can help you during your incapacity, whereas a will doesn't help you at all there. A trust can help you avoid guardianship and conservatorship, whereas a will doesn't help you at all in that scenario. Okay. Now let's talk about cost. And this is a superficial thing. Estate planning decisions shouldn't be made based on cost. This is coming from an estate planning attorney, so maybe you don't believe that, but it's true. It's true. While a will might be cheaper up front, you should be considering the costs that might come up later with a will. So what are some of these hidden costs? Well, one of which is probate. With a will, you're going through probate. That means you're going to court. You're hiring a lawyer in most cases to help you with that. I'm one of those lawyers. I do probate, and I'm happy to help someone with probate, but I'm much happier to help someone prevent it. Because cost-wise, a will and a probate are probably double what a revocable trust would cost to set up at the beginning, where you would avoid probate and make the hassle of everything so much easier. The next thing to consider between a will and a trust is control over distribution. So with a trust, you can control how your estate's distributed more simply than with a will, which just gives a straightforward approach. Okay. So dealing with minors, if you want to incentivize beneficiaries, if you want to protect people that have disabilities, you do all that through a trust. Whereas with a will plan, in the will, you're probably not going to do sophisticated planning like that. Oftentimes, we can do like a minor's trust in a will for minor kids to hold their money until they're adults. But you're not going to do more extensive planning than that in most cases. So James, how are life changes dealt with differently between a will and a trust? So the answer to this question is it's just as easy pretty much to amend a will as it is a trust these days because of word processing, right? Everybody's got word processing. We're not employing floors of typists anymore like they were doing in the old days. I don't have a floor of typists to type up all these documents at once. I have them all on a computer and we type them up, based on forms that we have that are already written, and we fill in the spots and amend the spots and customize the spots that need to be customized. And so the same thing is true with a will or a trust there. It's all word processing. So there's really no difference as far as amendments go. One thing that might be simple or simpler with a trust is with a trust you can do like a simple amendment, whereas something that amended a will at one time was called a codicil. That's not as common anymore just because of word processing, but sometimes it might be even cheaper to do a trust amendment because you can just do a simple 1 or 2 page amendment. Whereas with a will, you're not likely to do a codicil that amends the will. I don't do them. I've never done one. In 22 years, I've never done a codicil. So, I don't know. Think about that, whatever you think. So, what about guardianship designation? So, with a trust, a revocable trust, you're not going to be designated a guardian for your kids. And one of the reasons that you have a will if you have kids, particularly minor kids, or in this scenario, only minor kids, your will designates the guardian. And that's the person that takes care of the kids if you're not able to, right? And a trust doesn't fill that role. A trust is dealing with the assets and not the designation of guardians for children. Typically, when you do a revocable living trust, you have both, right? A trust plan that I do has a will and a trust. The will is different, though, because the will that we create for the revocable trust is considered a pour-over will. So that basically means that if there's any assets that aren't in the trust, if any of your stuff is not in the trust when you die, put it in the trust through the will. Okay. Now, so I guess backing up, guardianship designation is one for the will. Okay. Now, how does real estate or assets that are out of state, how are they handled differently between a will and a trust? So if somebody owns property in multiple states, this can be a problem. If you have a will and you have property in Arizona or Idaho or California or wherever, North Dakota, South Dakota, I've got lots of clients out here that have property that they inherited in the Dakotas. It's very interesting. Anyway, if you have property in multiple states and you have a will, guess what happens? Because you have to clear title to those assets and you have a will, and the will has to go through probate at the court to get authority from the judge for a person to sign a will or sign a deed or something like that, you're going through probate in Washington, you're going through probate in Arizona, and you're going through probate in one of the Dakotas, north or south. I'm not sure which one's more popular for property. I think maybe north even, which is even more interesting. I don't think I've even been to North Dakota. I've been to south a bunch, but I don't know that I've even ventured up north. Maybe once or twice. Anyway, if you have a trust and you have that property in North Dakota and you've got that property in Arizona and you've got your house in Washington, you're going to avoid probate in all 3 of those states, because the trust allows the trustee, person in charge, to deal with assets without having to open a court case, which is great. Finally, creditor protection, will versus revocable living trust, there's really no difference. Trusts, some kinds of trusts can provide creditor protection. The revocable trust that we're talking about today, which is the typical trust that people do as a will substitute, isn't an asset protection trust. So it's basically you on paper. So we're not really doing it for asset protection. We're doing it because we want to avoid probate. We're doing it because we want to avoid estate taxes. We're doing it because we want to avoid things like guardianships and conservatorships. We're not doing it for asset protection. If you're looking for asset protection, there's other ways to do it. But the revocable trust is not one that we use for that. So that's probably a wash, right? But I think overall, if you're scoring, I didn't keep score on this thing, but the reality of it is that a will is better than a trust, okay? The reality of it is that a trust is better than a will. A trust is better than a will because it avoids probate, it avoids guardianships, it avoids the hassle of multi-state probates, and just makes it so much easier and simpler to manage. So next week's episode, we're going to talk more about a trust, and we're going to talk about why it's the most effective estate plan in almost all cases, okay? And so stick around for that one, and hopefully this episode has helped you to sort of see the difference, okay, between a will and a trust. And that's it. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.